Good afternoon, ladies and gentlemen. I am delighted to welcome you all to this esteemed panel discussion on cross-border estate planning, hosted by the East Africa Law Society in partnership with CM Advocates LLP. My name is Melissa Warimo-Mashua, and I'm honored to serve as your moderator for today's session. So today we have the privilege of being joined by distinguished legal experts and financial professionals from across East Africa. I would like to extend a warm welcome to our esteemed panelists from Kenya, Uganda, and Tanzania, who bring a wealth of experience and expertise in the field of estate management, and of course to our lovely audience. I will introduce our panelists in just a moment, but before I do so, I would like to take a moment to outline the structure of today's session and some housekeeping rules. Our discussion will be divided into two main segments. In the first segment, I'll be posing questions to our esteemed panelists to explore various aspects of cross-border estate planning. During this time, if the audience have any questions, please submit your question and submit it in the question and answer feature. Please also indicate the panelists that you would like to answer your question. Once we are done with the question and answer session with myself and the panelists, we'll move on to the question and answer segment with the audience. So we will endeavor to answer as many questions as possible. However, if we are unable to do so due to time constraints, I'll ask that you please email your queries to info@ealawsociety.org, and you will get feedback via email. I will put the said email address in the chat box. Today's session will be recorded for informational purposes and will be shared with the participants within the next 48 hours. So allow me now to just introduce our panelists by reading through their bios. Panelists, if I may ask that you please put on your cameras, just so the audience can see who I'm referring to. Thank you. First, we have Dr. Henry Onoria. So Dr. Henry Onoria is an eminent law scholar with over 30 years experience in legal education, training, and practice that covers the breadth of the justice, rule of law sector, academia, law reform, legal practice, and courts. He taught constitutional law and history at Makerere University and additionally taught several law courses at the University of Juba, including the Law of East African Community. He has previously worked with the Uganda Law Reform Commission as a national consultant on reform of commercial law and the Commission of Criminal Justice Reform. He served as a legal education and training advisor to the law school at the University of Juba, the Justice Ministry, and Judiciary of South Sudan immediately following South Sudan's attainment of independence in 2011 and 2018. Presently, he is the knowledge consultant and head integration and cross-border transactions practice at ALP Advocates, which is part of ALP East Africa, an integrated legal and consulting firm with offices in Kampala, Nairobi, Dar es Salaam, and Juba. Over the past 4 to 5 years, he has led in training of EAC partner states, national judiciaries, and legal professionals on the law and procedures of the East African Court of Justice, EACJ. He has a Bachelor of Laws degree from Makerere University, Diploma in Legal Practice from the Law Development Center, and Master of Laws and Doctor of Philosophy degrees from the University of Cambridge. Welcome, Dr. Henry Onoria.
Thank you, Melissa. Glad to be here.
You're welcome. Next, we have Diana Muriithi Gishuru. Diana Muriithi Gishuru is an advocate of the High Court of Kenya, currently practicing as a partner as the head of unit of the Wealth and Private Clients Departments at CM Advocates LLP. She has a wealth of experience in planning, structuring, and devising long-term estate plans for various clients. Her practice cuts across matters trust law, family law, succession law, corporate and commercial law, conveyance practice, as well as tax laws, establishing herself as the go-to expert for all matters private wealth and private clients. As head of unit for the Wealth and Private Clients Department, Diana has worked with numerous families and family businesses in Kenya and the region. She is passionate about educating family businesses on proper corporate governance structures and having efficient business succession plans. She has partnered with esteemed organizations such as Strathmore University, Kenya Private Schools Association, and Association of Insurance Brokers Kenya as a resource person on topics and issues touching on her expertise. Diana is a non-executive director in the board of Gabriel Trust Corporation as a wealth management expert. Diana holds a Bachelor of Laws degree, Diploma in Law from KSL, and is currently pursuing her master's in clinical psychology. She has a professional certificate core specialization in business strategy from Harvard Business School and is a member of the prestigious Women in Boards Network, an organization that is committed to promoting gender diversity and leadership in the corporate space. Welcome, Diana Kishore.
Thank you, Melissa.
We also have with us Mona Doshi. Mona Doshi is a partner at ALN Kenya and Jawala & Khanna and co-heads the firm's private client department. She looks after the affairs of high net worth clients. Her practice includes advising on succession planning, drafting wills, handling probate matters, advising on offshore and onshore trusts, drafting shareholders agreements for family businesses, advising on prenuptial agreements, drafting settlement agreements, and advising on real estate. Mona handles both local and multi-jurisdictional matters for private clients. She also acts for several charitable institutions and has assisted in setting up charitable trusts and foundations. She is ranked by Chambers Global H&W guides that ranks lawyers with expertise in handling private wealth matters. She's an advocate of the High Court of Kenya. She holds an LLB from the University of Reading and has completed the LPC at College of Law, Guildford, England. Happy to have you, Mona. Welcome.
Thank you so much.
So we also have with us Dr. Alex Nguluma. Dr. Alex Nguluma is an advocate and managing partner at Rex Advocates. He's a holder of an LLM from the University of Dar es Salaam, PhD from the University of Warwick and the University of Dar es Salaam. He has 35 years of experience and specializes in tax and corporate consultancy, tax and commercial litigation, commercial arbitration, liquidations, and receiverships. He has acted for clients in a variety of transactions, including mining and telecommunications, banking, manufacturing, and insurance industries. He previously lectured in the law faculty at the University of Dar es Salaam and has been involved in drafting and reviewing key Tanzanian legislation. Welcome, Dr. Alex Nguluma. I am not sure if he's managed to log on, but we hope that he'll be able to do so shortly. Now I've introduced our legal experts. I will move on introducing our financial experts. We have with us today Mr. Alex Mungai. Alex Mungai is the CEO and managing partner of Moran Capital Limited, a specialist wealth management firm established in 2011. He is a finance professional with a proven record of over 20 years of senior management roles in accounting and finance, insurance, fund management, and investment banking operations. Alex completed his master's in finance at the University of Kent, Canterbury. He has since been engaged in numerous educational pursuits, including certifications from Trainer of Trainers for Euromoney and the College of Insurance. Alex, together with his partner Vera, are family life coaches. He is passionate about creating, growing, and protecting generational wealth for families and catalyzing growth of dollar millionaires in Africa. Welcome, Alex Mungai.
Oh, thank you, Melissa. Glad to be here.
Glad to have you. Thank you.
Thank you.
And last but not least, we have Kamoga Ahmed. Kamoga is a certified trustee with the Uganda Retirement Benefits Regulation Authority. He's a certified risk and financial advisor with IRA and the Capital Markets Authority. He has a diploma in insurance from the ITC. He's a risk and investment advisor with UAP Old Mutual. He has 14 years experience in the insurance and investment industry, and he's a CEO of Livingstone Basketball Club and trustee of Mazima Retirement Plan. Welcome, Kamoga Ahmed. I think he will also manage to join in a bit later. So as we begin, I would like to emphasize the significance of our topic today. Estate planning, particularly in a cross-border context, is a multifaceted area that intersects law, finance, and personal planning. As our globalized world continues to evolve, individuals and families increasingly find themselves navigating complex and financial landscapes when it comes to managing their estates across different jurisdictions. For lawyers especially, understanding the nuances of cross-border estate planning is not only professionally enriching, but also essential in providing comprehensive legal counsel to clients with international interests. Today's session will shed light on key considerations, challenges, and best practices in this vital aspect of legal practice. I'd also like to express our heartfelt gratitude to the East African Law Society and CM Advocates for their support in organizing this session. I encourage our panelists to share their experience generously, and I invite our audience to actively engage in this enriching dialogue by submitting their questions in the Q&A feature. Thank you once again for joining us, and without any delay, we can start on our session. So, as a kind of foundation, just to kind of get people understanding what estate planning is, we think it would be vital to first understand what are the available estate planning tools that are in the various jurisdictions. So I will ask a few panelists to kind of give an overview of the estate planning tools in their respective jurisdictions, highlighting both the advantages and disadvantages of the tools presented. Dr. Henry Onoria, if I may start with you.
Yes, thank you, Melissa. I think the tools, and just to introduce to the audience, I think those who studied in Makerere will probably understand what estate planning is, because there's a full course offered titled estate planning. So that wouldn't be strange, but just the term by which people then plan the administration of their assets and any liabilities during their lifetime and after they pass on. Now, in Uganda, where I come from, they are primarily, I can probably say, these are the foremost tools: wills, drafting wills, and this is usually provided for under the succession laws. Most all of the East African and other countries have succession acts or some form. In Uganda, we amended our act recently in 2021. It's an old colonial law, but we keep updating it. Now, this is a tool that allows you to, while you are still alive, to provide a listing of all your assets, a listing of all your beneficiaries, and you can then determine who you allocate which particular asset in terms of either property, shares, and any other assets that you have. This can be something else. The beauty about a will is that it gives you time to plan. You can then decide which properties do I give to who. If you accumulate more property or the assets grow, you can then change the will, you can update the will. Now, one of the things that I just want to point out that during COVID, it dawned on us in Uganda that many of us were actually not using this tool, even if it's available. People died, and all of a sudden, the courts were filled with people applying for letters of administration instead of letters of probate, because there were no wills. And that created a whole set of havoc. I think eventually the authorities decided to even design, they provided a template of a sample will so that people can begin doing wills. Now, wills have their disadvantages that while it should be easier to deal with in probate, because that's what probate proceedings would be. The will is proved and then executed by the executor. Too often, this can take too long. Some people complain that they are not included in the will, so there can be challenges of wills contestation, whether the person who made the will was in the right state of mind at the time. So those are the things that will come out, but wills should be the primary tool. The other one is trusts. Again, in Uganda, we have very old trust laws. There's the Trustees Deed Act, the Trustees Incorporation Act. The latest amendments have only mainly been due to include the beneficial ownership requirements as part of anti-money laundering. Now, this is a framework which allows you to prepare for trusts. There are new versions of it, which are usually for retirement benefits. We have sort of modernized our retirement scheme outside of the traditional NSSF. to provide for other people who might want to invest their retirement. And there you'll find unit managers, you'll have advisors on how to invest those retirement benefits. Now, this usually, you can decide where you want to get high yields. It could be investments in government securities. So there'll be someone to advise you. Now, the advantage is that if you have a high value client, I think I've seen from most of the way, some of them have advertised that if you have like 100 million Uganda shillings, they can take you up and show you where to invest, which trusts to invest. Okay. Now, often trusts, they will just want to point out one key disadvantage, that trusts are often complex. So this requires not just the legal expertise, but also, since we have those on, as part of the discussion today, financial advisors, tax advisors, and they will probably advise you where you can get best returns for your investment or as a trust. Just to finalize, to conclude, we have had difficulty with setting up trusts in Uganda because of the nature of the old law. They're sort of pegged to land, that you must create a trust that then has a whole land as a holding real property. So sometimes that has had been sort of created its own obstacles. You need to have come with the property for you to create a trust. So that's just sort of something which we need to decouple trust from, especially all the traditional forms of trusts in Uganda. So I just thank you. Those are just my quick take from Uganda.
Thank you very much, Dr. Honoria. Diana, if I can come to you, we've heard some very interesting insight from Dr. Honoria, particularly mentioning that the legal framework in Uganda regarding trusts is scattered in various pieces of legislation. So is that the same case for Kenya? And apart from the wills and trusts, are there other estate planning tools available? And what are the respective advantages and disadvantages? Thank you.
Okay, thank you, Melissa. Yes, it was very nice to listen to the doctor. In Kenya, the position is a bit different. I think we've had a change of law that was posited in 2021. Our Trustee Perpetual Succession Act was amended in 2021. That was a long outstanding amendment since the last time it had been amended before that was, I think, in the 80s or in the 60s. This amendment, coupled with the amendment of the Perpetuities and Accumulations Act, have now grounded our trust laws, so that the net effect now in Kenya is that our trust laws are very strong. We can now incorporate family trusts, meaning they can be corporate bodies that can then hold the assets in their own name, and therefore that makes administration and management a lot easier. Additionally to the amendments in 2021 was some amendments through the Finance Act 2021 and subsequent amendments through Finance Act 2023 that have also clarified the tax regime for family trusts. So those cumulative amendments have ended up creating a very effective and very stable environment and regulatory framework for family trusts, so that now family trusts are well grounded as a tool of succession planning and also as a tool of wealth management, because unlike all the other tools I'm going to discuss shortly, family trusts, particularly when registered as a living trust during the lifetime of the testator or the settlor, that's a person who's planning his wealth, can then be used as a tool of wealth management, and a very effective tool as that. So yes, other than the will, we do have many other ways of conducting, many other estate planning tools in Kenya. I think the most popular with regards to incapacitation is powers of attorney, whether general or specific. I think in my practice, what I've observed in the last 1 to 2 years, I've seen a lot of people who've had to apply to court because of mental diseases relating to the Mental Health Act, whereby they end up losing capacity, mental capacity, where they're still alive. So diseases like Alzheimer's, dementia, which have then affected their mental faculty. So under our current laws, if such a person had not, prior to losing their mental capacity, or made arrangements for how the affairs would be managed, say either by donating certain powers through a power of attorney, they would have to file an application called an application for guardianship or legal managership at the High Court, at which point the High Court would then adjudge this person as one who has a mental disorder and therefore appoint a manager over his affairs. So with regards to capacitation, we've seen a lot of uptake for that. The other type of tool I think we see a lot, we've talked about the wills in Kenya. The thing about Kenya, let me just mention about wills is they still have to go through the probate process. They have to be proved in court before they're then implemented or actioned. Then the other two tools are, we have certain classes of benefits, certain classes of assets, particularly WIBA benefits, insurance benefits. These ones are the form of nomination as filled out by the settlor or testator during his lifetime is the one that will dictate to whom these assets transmit upon death. And then finally, we have the most, I think one of the ones that are most popular is also by way of gift inter vivos. That's just a gift given during their lifetime. So we do have some testators who decide to actually bequeath their gifts when they're alive. And the catch here is that you must make sure that the gift transmits when the testator is still alive. So with regards to that, you would need a lawyer who has proper competencies in tax planning so that you avoid triggering too many very onerous tax events. So for instance, if a father was trying to transfer property to his son when he's still alive, or to maybe his son and his daughter-in-law and he's still alive, he may decide to use a family-owned company or use a family trust. Those ones would be tax-exempt transactions. Therefore, in totality, in Kenya, I think those are the 5 most common estate planning tools, but also you'll find that in Kenya, the family trust does not sit as an orphan structure. It doesn't sit only as a trust. Many times there will be either holdcos, holding companies, there will be trading entities, depending on the type of assets the person has, depending on how their asset portfolio sits, there will be other entities below the trust, which would then all together encompass the trust structure.
Thank you very much, Diana, for those key insights. Dr. Nguluma, if we can come to you to get the Tanzanian perspective, we are seeing an interesting dynamic in that Uganda has the laws regarding trusts scattered in various legislation, and it's difficult to register a trust, whereas in Kenya, there are actually specific legislations in place that regarding trusts, and it seems relatively easier to be able to establish a trust. So where does Tanzania fall on this spectrum, and what do you see as some of the unique aspects of the Tanzanian law with estate planning tools? Thank you. Mr. Nguluma, you're muted. So
yes, thank you, Melissa. Thank you also, Dr. Henry, Omoria, and Mona for your insights. In Tanzania, I think like Uganda, wills and trusts are the most common tools for estate planning or wealth planning. Wills are regulated under the Probate and Administration of Estates Act, which was last revised in 2019, but basically it has not undergone any major changes since the early independence period. Wills are favored by most people, but they are not very much used. I would say not many people are aware of the importance of wills in the management of their estates, particularly after passing on. However, we both indigenous and foreign heirs are protected by the law when identified via the will. So, for instance, a foreign heir, even if he's from UK, from Kenya, from Uganda, from whichever country, if mentioned in the will, can inherit assets which are domiciled in Tanzania. There are no inheritance taxes at the time being, because property which passes after the death of the through the testator, they pass by operation of law. So there are no tax tags that are carried with them. Now, like in other jurisdictions, wills are only enforceable upon the death of the testator, and these have to go through court processes, and they have the disadvantage of this inheritance where a testator is uncomfortable with some of his or her heirs. Enforcement may take time, sometimes years, if the will is contested. As I said earlier, wills are not used widely. They're the most common, but they're not used widely. And I think education about their importance is crucial, not only to the majority of the people, but also to lawyers, because many lawyers I've seen in this environment who have passed on without leaving a will, and a lot of confusion happening tends to engulf the estates. So education is key here. As for trusts, we have a trusts incorporation law, which like the wills one, and the other one was last revised in 2019. But again, it is not dedicated. There's nothing dedicated to wealth management. Is generally it talks about trusts. So, but many those who are aware of this law have structured their trusts for private wealth management using this general law. The problem with our trust incorporation law is that it takes a very long time now in Tanzania to register a trust, and this has became complicated after the September 11th bombing of Tanzania, Kenya, and some other countries, where anti-terrorist laws and rules and regulations and anti-money laundering rules and regulations have actually engulfed this area. Trusts are taken as if they can be used as tools to pass to money launder and also to fund terrorism acts. So there are a number of checks and balances. So it can take up to even a year or more to register a trust. This it makes it become cumbersome and not interesting for the time being. It is also expensive to maintain. For those who have opted to maintain the trusts as a tool, find it expensive to maintain them, because professionals, they have to be managed by professionals like accountants and lawyers, who have to be periodically paid throughout the life of a trust. So it's an expensive tool. We need to have a lot of wealth to prefer the trust's route. It also, in Tanzania, we have also noted some common problems of trustees misusing their powers and take advantage of the assets in trust for their personal gains. This has happened in some cases. But generally, trusts, though, if you had a good law like the Kenyan one, it's quite a good tool for private wealth management. But the current law, the law that we have, is not very favorable for this tool, and therefore the trusts are rare in private wealth management in Tanzania. Apart from the two, I mean, wills and the trusts, well, other tools that are available are powers of attorney, like the what Mona described, but these in Tanzania they're not usually used for wealth management. They're used for land transfers, etc., etc. Perhaps it's an area which we need to learn more and try to. It's a usable. I think it's a tool to a certain to a limited extent, but it's not very much used in this area.
All right. Thank you. Thank you very much, Dr. Kaluma. And thank you for also pointing out that lawyers sometimes do not have wills in place themselves. You know, they often say that doctors make the worst patients. So it may be that we are the worst at taking our own advice. So a word to all of us lawyers, we need to get our estate planning in check. So thank you to the lawyers. We've now had the legal aspect, and now Kamoga, maybe we could hear from you on the financial aspect. Are there estate planning tools available with the financial aspect, and what are those advantages and disadvantages? Thanks.
Thank you, Melissa. I hope you can hear me. You can hear me? Very perfect,
yes.
Yeah.
Yes.
Thank you, Melissa, and thank you to the panelists. I'm happy to be here. Yeah, it's important for people to have trusts and have wills to know who is going to probably take care of their assets, for that next generations. Now, in the financial aspect of, I like what Dr. Alex said, that it's nice to get professionals to run those, those trusts and wills. It's also important to get professionals to give you professional advice in terms of investments. Yeah, now, there are so many investments you can have. Let's say someone left, let's say $1 billion shillings on their bank account, probably take care of his estate or his family. So are you going to leave the money in the bank doing nothing? So why don't you probably agree, the trustees, why can't we invest this money so it can earn income and takes care probably of the next generations? So there's so many tools or so many financial instruments that you can use to invest money. The one that they are highly recommended or known ones in the financial sector, especially in Uganda, we have life insurance policies, those long-term savings schemes and payouts and endowment policies. We have the unit trust funds, which currently are the most trending ones in the financial markets here in Uganda. We have annuities, which haven't picked up in Uganda, but as of last quarter, I read somewhere we have last quarter we collected over 100 million shillings worth of clients who have annuities. Annuities whereby someone puts money there and it's going to take care of the next generation probably until death or something. So we also have treasury bills and bonds. People may decide to invest money there for long term or even short term. Then we also have the stock market. People buying shares. These days it's even cheaper. You can even buy shares off your phone. Look at the apps like Cheaper Cash. You can buy shares, outside your your jurisdiction and outside your country. There is also fixed deposits. You can probably fix that money and earn income to take care of the next generations. So all those 5 financial instruments have advantages. When you look at the life insurance, I mean, it pays out on death. It's sum assured, so it takes care probably of your disability needs when they happen. Though the challenge with the life insurance policies, of course, you must be committed to to contribute money on a monthly basis. If you feel probably some companies can charge you, or your policy may end up being cancelled or something. But the ultimate goal that it gives you peace of mind and financial muscle to take care of your long-term goals. When you look at the unit trust funds, I mean, the flexibility that they have, in case you have probably another investment you have to engage in, You can come and pick up money from the trust fund and then go invest somewhere. Then the confounding interest that the trust funds have and the tax elements. There's someone here talking about taxes, the tax benefits. Yeah. So the unit trust fund has those tax benefits that can benefit from. Then when you look at the fixed deposits in the bank, the withholding tax on them, probably the low returns. In other words, you need to gauge that where does it make business sense for me to invest. But all in all those financial instruments are good to invest, even diversify. Yeah, so basically the unit trust funds, the life insurance policies, annuities, fixed deposits, the money market, treasury bills and bonds are good to invest in for someone who has left probably some money behind, probably some assets behind. You can probably sell your property to have cash assets, yeah, that can easily liquidate. Yeah, so Melissa, that's it from me.
Thank you so much. And just to clarify, you've mentioned something like life insurance. I imagine for something like that, you wouldn't have to go through the probate process for that insurance to be paid out to the beneficiaries. But what about for the, for example, fixed deposits? Is there that requirement that interlink with now the legal, where someone has to bequeath those funds in the fixed deposit? Or is it that once you have a fixed deposit, then automatically you name your beneficiaries and you avoid the probate process? How does that work?
Yeah, it's possible that when you have a fixed deposit, you can easily name your beneficiary. And in case anything happens to me, I mean, this money goes somewhere. In recent times, there's something the banks have designed. Someone probably will mention it. There's a form where I appoint people that in case I pass on, this money goes to these people directly. And there's not so much bureaucracy to get money. Yeah, so your fixed deposits also have that element that when I pass on, this money goes to this, beneficiary or next of kin.
Okay, great. Thank you for that clarification. So thank you, panelists. That was a great foundation. Before I move on, just to inform the audience members who may have just joined us that should you have a question, please indicate your question in the question and answer feature, and also indicate who you would like to answer your question. So moving on, Mona, if you could come to you. Let's say a client approaches you for cross-border estate planning and they have assets located all over the world. What are the key factors that you would consider in the planning process? And are there some that you would give priority over others? How does it work? Thank you.
Thank you, Melissa, for that question. So yeah, I would broadly say that these 5 kind of questions are important to understand. Firstly, the family, the assets, the laws, the taxes applicable, and the choice of advisors that you use in the various jurisdictions where assets are held. So it's important to understand the client and what his family composition is. It is important to find out what the client's domicile is, because, for example, under Kenyan succession law, the succession laws would be dependent on that person's domicile. We need to understand his domicile as well to understand what the laws of other jurisdictions say in respect to succession planning as well, as far as domicile is concerned. We need to understand if your client has any dependents that he doesn't wish to provide for, and why he doesn't wish to provide for them, because we need to be very clear when drafting wills or any documentation to assist him. We need to understand where his family resides. Nowadays, families are not all in one place, they are spread across the world. So what kind of taxation is going to be applicable to the family member who resides overseas? And when you are providing for that family member, how is that tax status going to be affected? And once you know that, you can help structure the planning accordingly so that the tax is minimized. The second set of questions relates to assets. Where are the assets located and what is the nature of the assets? So is it real estate? Is it bank accounts? Is it shares, bonds, and so on? and in which jurisdictions are they located? Are they in your client's name? Are they in a company's name? Are they jointly held? All those factors assist you in helping your client to plan effectively. How does your client want the assets to be distributed? Does he want equal distribution to his family members? Is he leaving particular assets to a particular family member? Is he not providing for a particular family member? Then you need to see that, okay, does he require a trust? For example, for business continuity, would he want the shares in his business to be held by a local Kenyan trust if it is Kenyan shares, if it's a Kenyan business? You would advise, depending on what his intentions are with those shares, with the business continuity that he may wish to have. For other assets, it may be wise to prepare a will. For global assets, you may prepare wills in each jurisdiction, because probate processes in each jurisdiction have their own length of time. Kenya may be a bit slower than other jurisdictions. So if you want your family to have access to funds, you may wish to do separate wills so that probate processes in various countries goes concurrently, so that if a country, the probate process in one country is faster, then at least the family has access to those funds in that jurisdiction. You would need to consider the laws of each jurisdiction as well, because the laws in Kenya, for example, we do not have inheritance tax, but laws in other countries, there is inheritance tax payable. So how do you effectively structure the assets in those jurisdictions so that there is not as much inheritance tax to pay? I've mentioned residency of your beneficiaries is also important, because you may wish to put those kind of assets in trust structures to minimize the tax that they pay when they inherit in other jurisdictions. So laws and taxation are very important when you're structuring a cross-border estate, because taxation in other countries becomes quite relevant to look at, and tax planning becomes very important as well. Where it is a Muslim person, Sharia law becomes important to look at, because in certain jurisdictions like Kenya, you have your succession laws, but the distribution under Sharia law is different. So one needs to also look at that and advise a Muslim client. Choice of advisors becomes important, because you want to work with good advisors who understand succession laws in their jurisdiction and who are able to also give good tax advice. So broadly, those are the things that initially you would look at when a client approaches you.
Well put. Thank you very much, Mona. Just to also follow up, are there certain assets that you find relatively more difficult to deal with than other assets?
So it depends in which country the asset is located. For Kenyan assets, for example, transferring certain types of real estate into a trust, you would be looking at, you know, do you want to pay that much stamp duty? Do you want to pay that much capital gains tax? For if you're structuring it using a family company route, you can minimize the tax payable. So it really depends on where the asset is situated, which country it is located in, and what the client wants to do with it, so that we can give the best advice.
Great, thank you. So what I'm getting from that is, once you factor in all these considerations, then you can now decide which is the most effective estate planning tool. Dr. Honoria, if you could come over to you. How about you? What are the factors that you consider in the planning process that may be different from what Mona has just told us? Thank you.
I think Mona has probably touched on much of the areas. At the end of it all, I think what she has mentioned is that you need, as a lawyer, to keep abreast with legal developments. Because if you're going to engage in cross-border investments for purposes of broadening and expanding wealth, then you need to know the legal developments in those jurisdictions. And also pay attention to the sector. Now, the laws will inform you which sector you are looking at. For instance, Mona has mentioned that you might want to invest in, I think also our financials, that you might want to invest in, say, shares or want to invest in government securities. So you need to know what is the law in the country that the client is asking you to invest in. I can just take a quick look at, say, Rwanda. Rwanda has done a lot in revamping its tax laws. It revamped its income tax law last year, had very interesting amendments this year. Now, if you are doing trusts, especially foreign trusts in Rwanda, then from point of tax planning, I think because they're trying to encourage more trusts, foreign trusts to come in, then the chances are that the interests that come from that, I think, are income tax free. If you are going to invest in shares that are low, that are floated on the Rwanda Stock Exchange, then once you decide that you want to dispose of those shares, then their capital gains tax free. So there are benefits, sometimes identifying why the person wants. And I think this is where now the financial will advise you. But of course, we the lawyers would know what is going on. Let's take Kenya. I think in the peak of COVID, Kenya was trying to encourage people to invest in the vaccine manufacture industries which were in. Now, if you are a foreigner who then invested in a company that was doing vaccine manufacture and dividends were paid, then those were income tax free. So the idea is that now you begin to look at as a lawyer, what are the developments that are going on in other jurisdictions? But just to wind this up, keeping to trusts, which is the critical tool for wealth generation. One of the things that has happened is that as countries like Uganda, Tanzania have been trying to modernize and amend all the laws, all the post-independence laws. There are other countries which are actually revamping and issuing new trust laws. I can just mention, I think Kenya has its Trustees Perpetual Succession Act. Rwanda issued a new law governing trusts in 2021. Botswana has a Trust Property Control Act of 2022. And then Seychelles has a Trusts Act of 2021. Now, what's interesting is that these are modernized versions that are taking into account the developments across the board. Now, one of the things that Mona pointed out, the issue of domicile, the issue of being attentive to what will be the applicable law to deal with the trust. Now, the Trust Act of Seychelles 2021 and the Section 5 has detailed description of what will be the applicable law to the trust. And if those of you who have studied the estate planning conflict of laws, it has actually captured the principles of conflict of laws. If you can just allow me to just glance with, it just says, the proper law of the trust shall be the law of the jurisdiction expressed first by the terms of the trust as the proper law. Now, B, if it's not expressed, it's implied from the terms of the trust. And thirdly, if both there's no law expressed, the state law can be implyable, then the law to which the trust at the time it was created has the closest connection. These are pure principles of conflict of laws. So as a lawyer, you need to begin looking at, if a client tells you, because sometimes the client has an interest, maybe because they have close connection to a particular country, or they visit the country more often and feel that they need to invest. So you need to be able to quickly tell the client, I can look up the law and see what is the best vehicle for you to invest. I can look at which sectors you can invest in. I can look at what kind of tax planning, whom can we get, which advisors can we look up in that jurisdiction to help with the planning for investment and all that. So I think for me, just to sum up what I would probably say, let's keep abreast with the legal developments in the jurisdictions. That's very critical for me. Thank you.
Well put, Dr. Noria. Thank you so much. Kamoga, if you can come back to you now on the financial aspect, what are the factors that you consider?
Thank you, Melissa. Yeah, as lawyers are keeping abreast of the legal developments, in the different industries, it's also important for people running trusts or wills or to seek financial guidance from professionals. Yeah, in Uganda, there are a number of them, like the stockbrokers, the fund managers, then risk advisors and financial advisors from financial institutions. So the things you consider, Mona said, all that's like knowing where the asset is, the laws in different, countries. Then what next? Yeah, you have the money. So how are you going to how are you going to utilize it or invest it? And where are you going to invest it? So you need to understand some aspects that have my 100 million shillings. Where am I going to put it? What am I considering? One, you must consider the income, the investment income. How much interest rates are you going to earn on that, on that portfolio? Which probably fund manager or which bank is giving high returns, and then go for that. Also, you need to understand the taxes, as Dr. Hendra said, which tax regimes affect what investments. Employees that run their trust funds, probably, the income you earn is tax-free. I don't think I got that right. But in Uganda, our unit trust funds, the income you earn off them, they are tax-free. No withholding tax, no income tax. So it's an advantage to the person running a will or running someone's trust, that I need to invest my money here because there's no taxes on it. So I'm getting my income as a whole. Also, you need to understand the flexibility of the assets. That if I need money, am I going to liquidate my asset immediately, or I need to wait probably till maturity? So you need to consider those factors: the income you're earning, the flexibility of the asset you're investing in, and the tax element on that investment. And also, is the investment really regulated? That am I dealing with the financial instrument that is regulated? In Uganda, there's so many financial things that are coming up. People get to lose money because the things they're investing in are not regulated. So be cautious. Make sure that the things you're investing in money are regulated by the government. Yeah, thank you.
Well put as well. Thank you very much, Kamoga. Anna, if I could come to you. From your experience, what are some of the challenges associated with cross-border estate planning, and how does understanding the role of a lawyer contribute to overcoming these challenges?
Thank you, Melissa. I think challenge number one would be what has come out very clearly as all the three previous panelists were talking, the lack of harmonization in laws. So that, for instance, when I've planned estates that had holdings in South Africa and Tanzania and Kenya, I was constantly, I have to, as we pointed out before, I have to consider and work with experts in all those jurisdictions. Considering the ESC and our common market protocol and everything, I wish that now that the Tanzanian laws on trust, the Ugandan law on trust are just developing, and I think also in Rwanda, I don't know if someone said in Rwanda there is no law yet, but I think it's in the offing somewhere. I wish there'd be some more harmonization. I think that would be easier. But of course, number two, complexity is the tax implication. And I think that's the most important thing here. So for instance, when I've structured an estate that had holdings in South Africa, we had to have different trusts because the net effect of having the Kenyan trust own the South African holdings was taking the tax rate to almost 48%. So when you look at that, it becomes very tax onerous and tax inefficient. I think the other issue, cultural differences sometimes, because you'll find that the attitude in, say, jurisdiction A regarding the idea of just bequeathing assets, transmitting assets, transferring, and the attitude in other jurisdiction, not similar, yeah? And then also, for instance, maybe in Kenya, there are certain developments with regard to how we do business that haven't been made in other jurisdictions. So I think those are some of the things we see in terms of the challenges with cross-border estate planning. But I think the solution is just fun. It is work with the experts because they are able to advise on practical things. I think just about 2 weeks ago, Mauritius issued the notice stating that now they'll be exchanging information with our government. So that now also, as we're making considerations for whether is there a need for even an offshore trust at all or is there none, then you realize that maybe some of the benefits you're going so far to get, you can get them here, homemade, locally. And then actually some are even now not available at all. So that it's no longer just a question of sitting down and asking yourself, oh yeah, so I want to have a trust, it needs to be in some tax haven somewhere. If you consider your local laws like ours, as I have told you, are very good. So working with an expert would help you achieve your objective while avoiding those pitfalls, yeah? So yeah, I think that's about it. Oh, in overcoming, sorry, I think you asked overcoming. I've said that in overcoming, work with the experts. And I just wanted to mention, like in Kenya, our current tax regime would allow for any movement of an asset, whether it's immovable property or if it's shares in the stock exchange or whatever, investment shares, it would allow for any movement of assets into the family trust as both capital gains tax exempt as well as stamp duty exempt, as long as we're moving the asset into the family trust, into a registered family trust, or we're using the proceeds thereof, we're settling the proceeds thereof into a family trust. So in terms of seeking out continuity, in terms of seeking out a better tax regime, you find that now we have homegrown solutions. So if you keep abreast with what has changed in the law, you're able to offer your clients and us actually yourself, because this webinar is also for us lawyers to better structure our own estates, you're able to find solutions that are suited to you. Yes.
Thank you for that wonderful insight. You mentioned some cultural differences. In your experience, have you come across language and communication barriers where some documents are in a different language, and when they're translated, it kind of loses the initial intention or meaning behind what the document was about? Have you come across something of the sort?
Yeah, I think this happened when we were in Burundi. I think with Burundi, a lot of the legislation is in French. And then also their laws their legal system is very different from the Kenyan legal system. So when you're trying to, also they have some restrictions regarding how the properties are owned there. So just trying to structure exactly how is this land held, how is this land then going to be transmitted in the event this person passed on, it was quite an uphill task until you get to the point where you're like, okay, now let your lawyers handle that. Once your lawyers have handled it and have told me exactly what they've done, we'll advise here. Or we get to the place where we're like, since it's a bit complicated, let's just have a will that is for that jurisdiction. And then later, if the assets are sold or if there's any proceeds coming from there, if the tax considerations make sense, we'll expatriate the funds. Yeah, so that's also definitely an issue that comes up, particularly where the local language is not like, maybe for instance, our most used language is English or Swahili, but mostly actually English. Where now, like in Burundi, most of them would have the documents drawn in French. Yeah.
Great, thank you so much. Dr. Ngaluma, how about you? Are there different challenges that you have faced from what Diana has faced, and how did understanding your role contribute to overcoming them? Thank you.
Right. Our experience is similar to what Diana has described, and also Henry. but I would just say that in this jurisdiction, we also face, or we see the problem of different application or application of different legislation in different jurisdictions. That's, for instance, a Tanzanian living outside Tanzania or a Kenyan living in Tanzania, etc., may not find a befitting professional advisor on estate planning tenable in his country of birth or domicile. So in future, the East African Law Society needs to continue pushing for harmonization of laws. I think it's Diana who proposed this. There is also a need to, for instance, for IMED, it was easier for him to quickly navigate the different forms of investments available in different jurisdictions, in most of our jurisdiction. But this is a challenge to investors. Many do not understand the different forms of investments available in our jurisdictions. And also to be able to gauge which ones are actually beneficial, those which are bubble, which may look like they are going to give an investor a very quick return, but actually for a certain period of time they are bubble and hyped. At the end of the day, an investor may lose. So to have someone who is professional in investments who can advise that you go for this and not this one, or you depending on what assets the investor has. The third one is again lack of or limited knowledge on cross-border estate planning. This is we have noted in this in the previous discussions. When was it in Burundi when we held our East African Law Society meeting there, and but yet many lawyers were not. Many of our members were not keen to actually join these meetings and trainings, because the lawyers need to also to open up and to get more knowledge on cross-border estate planning. Now, these challenges, like others have commented, may be overcome by through the use of professional advice. For instance, I speak for ourselves, lawyers. We are trained to find the law and advise clients on estate planning, befitting the assets of the client. So we are also equipped with trained, inquisitive minds to know how to find a solution to clients' problems. For instance, seeking advice from relevant legal practitioners or other professionals who can assist us as lawyers to assist our clients. So this is how I see it. Thank you, Melissa.
All right, thank you very much, Dr. Nguduma. Alex Ngai, if we can hear from you. From the finance perspective, what are some of the challenges that you faced when it comes to planning now these estates with its cross-border element, and how does understanding your role as a financial advisor help in overcoming these challenges?
Thanks. I think the first area has been mentioned a lot in terms of challenges is just that unification of laws, different laws. I think when you listen to issues of settlements, just within East Africa or so, you'll find that what you expect in the law in Kenya, when you go to maybe Rwanda or in another country, you find that that's not the same process that's used, and people need to know that that's what is there. So when you're sitting in one country and you think the law will be the same, that is one of the challenges we face when we are dealing with estate planning. So we have to work around, in Kenya, you have an organized space and around unclaimed assets, and you can go and do that. Now, when you go to other countries, you've got to also find who can take you through these processes of monitoring unclaimed assets, working with the lands. I think Diana has mentioned that. Those processes are all different. So it would be good to harmonize so that, you are getting the similar information in the markets. But of course, we work closely with, lawyers in different markets because they understand their local laws. And that's really, I guess, what we have to work with. We have obviously to work with many law firms or many firms around, different countries. And we are always looking for firms that have capacity within several jurisdictions, because when you are looking at the touch points you have to deal with in the investments and the land and all these things that you have to deal with, then you have to multiply this down the number of between the countries and the number of assets you are managing or trying to reconcile. That becomes a major challenge. And I think the last one being mentioned here is that conflicting tax rules. What you expect in one jurisdiction is very different in another jurisdiction, including the rules on succession and those kind of things. They are different depending on, as I think has been mentioned, where the assets are held at the time of the settler's death. So those kind of details, you really have to understand them, and you have to work with a firm that really understands the laws in the different jurisdictions. Otherwise, you are constantly trying to educate yourself as you're trying to execute, which creates a major drag, and it's very expensive to try and do that in multiple jurisdictions. Those are some of the issues that we find are challenges when we are dealing with estate, assets in different jurisdictions.
Thank you. Thank you very much, Alex Mungai. So from that, we understand that a major issue is the lack of harmony. And so hopefully we'll see some advances in that regard. Dr. Honoria, I'd like to come back to you. What recent trends have you observed in the realm of cross-border estate planning, and how do you anticipate these trends evolving in the near future?
Yes, thanks, Melissa. No, I think the trends are basically what's going on in society. We're no longer having the traditional forms of investments for purposes of wealth generation. In the past, you knew you could invest in a business, a physical business. So you went to, if you already had a business in Uganda, you then said, okay, can I expand to Nairobi? So you set up a shop, or you set up a factory, or you set up, or you could invest in a property. That's been the in thing. You go and build, get a lease or whatever, depending on the laws, you build up. Now, what has happened, of course, there were also companies, and then you could just buy shares and own it. What has happened over the past several years, decades, is that we're no longer having those traditional forms of investment platforms. So with the portfolios have changed, and now we have investment portfolios with what I would call attractive high-end returns and in new sectors. In the past, when you thought of how do you sell coffee or any commodity, you thought, okay, I'll just get my goods set up in a market and sell. But now these have ended up on the capital markets and the securities exchange. Now you have that form of investment. Now those are creating new, not only opportunities, but also their own kind of challenges. How do you manage and navigate these kind of new portfolios? There's been digitization that has grown across, as we have grown in digitizing literally everything. We're also digitizing how we sell and how we package investment. And often these are cross-border reach. I know that both Kenya and Tanzania now have income tax and VAT laws on digital services across borders and supply of digital services. Even the way we mobilize for investment. In the past, you floated shares and then you went back, maybe reissued new shares. Now we have crowdfunding. In the past, crowdfunding, everybody thought, okay, someone is in trouble. The traditional American approach, well, if we need to help someone out, we send out a call for crowdfunding. We get the money, maybe $100,000. We give it to the person in concern. Now we're crowdfunding for investment. We're doing digital assets, like virtual assets, cryptocurrencies. The other trends are carbon trading. So these are all becoming assets. It's such a strange idea that carbon trading is now an asset that you can say, okay, can we see how we can do carbon capture? And for that, we trade on the stock market and the like. Now, all these, as I think it was either Alex, there are two Alexes anyway, but I think he has dropped off. The gentleman from the financial sector in Uganda, Kamoga. Now, all these need to be aware that is there a law regulating this? Because he has pointed out that sometimes you can say, hey, this is an interesting area to invest, but there's no legal regulation, and then you end up having your fingers burnt by trying to invest in that area. Now, the good thing is that many countries are becoming attentive to these trends and are actually trying to regulate them. I don't know whether Mona and Diana are aware that there's a crowdfunding investment regulations out of Kenya, the Kenya Capital Markets Investment-Based Crowdfunding. You crowdfund not for purpose of just collecting money to give someone, but you crowdfund for whatever money you put, you get shares. So the crowdfunding is for investment. Now, what is interesting about these regulations of 2022 is that the crowdfunding platform operator doesn't have to be in Kenya. The only requirement is that you must direct the investment to Kenya. So the crowdfunding operator could even be sitting in the US. Now, you can imagine the kind of opportunities that you identify a business activity, you call for crowdfunding, and you offer people shares for that. So there are all these kind of innovations. I'll just end by, okay, for virtual assets, I think most countries are picking that up. Botswana has a law of 2022, Namibia 2023. I think Seychelles, Mauritius also has one. But I just want to point out a very interesting regulations that were rules that were issued by the Mauritian Financial Services Commission about 10 days ago. They took effect on 9th of February 2024. This is what is called Financial Services Spot Commodity Market and Intermediate Rules of 2024. Now, it talks about a spot commodity market, but what's interesting in that commodity market is what is called carbon offsets, which are tradable rights linked to business activities that lower the amount of carbon dioxide in the atmosphere. So you can see these trends. Now, you might find someone who might be interested in investing, and then you tell them there's this new area of investment. So now the question is, as a lawyer, you need to know the law, you need to understand what the implications are, what will be the tax implications, what are the procedures. But what is it? I'm trying to stress here that as long as there's a legal regulatory framework, it at least eases one's mind that these new trends and new opportunities for investment and wealth creation, I can at least invest there knowing that I'm protected. Thank you.
That's very, very interesting. Thank you, Dr. Noria. Mona, perhaps you can respond to Dr. Noria's question regarding the crowdfunding in Kenya and also touch on digital assets. Do we have any legislation that governs that in Kenya at present?
So as far as crowdfunding is concerned, I would actually take advice from investment advisors on the best way to handle that. And in terms of cryptocurrency, we have a bill that is currently in place in Kenya. We're just waiting to see, how far that will pan out and if it will become law. So currently there is a bill in place. Yeah.
Thank you. And also, are there additional recent trends that you have witnessed different to what Dr. Nori has stated?
Yes, actually, I think, with people becoming more and more internationally mobile, by that I mean, they're working in different parts of the world. Maybe their company is sending them overseas to work. Children are being sent overseas for education and they may get jobs in those countries. There is increase in global mobility. And that means people are purchasing assets overseas, maybe even having a second home overseas. Some of them are even getting, second passports. So it is important to understand that, things have changed over the last a couple of years, where just because you have a Kenyan passport doesn't mean that's your only passport. You may have another passport as well. And that affects the way you look at succession planning and tax planning for a client. Furthermore, businesses, we've mentioned that there can be a business across East Africa and there is no harmonization as yet of the laws. So until then, it is important for each business in each jurisdiction to look at their corporate governance planning, in each jurisdiction and also as a whole. It is important for businesses to put in corporate governance in place. It is important for businesses to look at corporate succession planning. So who is going to take over these businesses? I think, in our part of the world, where sometimes, it's hard for the next generation to take over because proper succession planning has not been done about how to, appoint the next successor. And I believe that, it is our duty as lawyers as well to guide clients on making sure that their businesses can survive and pass on to the next generation effectively. It is important to involve the next generation and, discuss how and who will take over in terms of businesses. So in terms of, I mentioned corporate governance, corporate succession planning, tax planning is also very important. Once we understand what a client, what kind of assets a client has, it's also important that we are not stuck with just them using one tool for their succession planning. We've discussed the various tools that are available. So wills, trusts, powers of attorney, shareholders agreements, even prenuptial agreements. We've started drafting prenuptial agreements because the Kenyan law recognizes prenuptial agreements. So we are seeing that, families are, starting to use a prenuptial agreement as a planning tool as well. So all these kind of tools are now there and available. And as lawyers, it is for us to look at a client's assets and advise them on the best way to utilize these tools for their planning purposes.
Thank you. Thank you so much for that. I think we've touched on this a bit, but Dr. Nguluma, just so we are sure, in Tanzania, are law firms offering a comprehensive range of private wealth services beyond estate planning, or is there a division of services between law firms, accountants, tax specialists, investment advisors, etc.? You're on mute, Dr. Nguluma.
Sorry, I'm sorry. Do you hear me now? Hello?
Yes, we can hear you.
Yes. Yeah. To the best of my knowledge and information, there is no law in the Tanzanian jurisdiction that offer comprehensive range of private wealth services beyond estate planning. Area investment advisory funds, management, accounting, advisory services, tax planning, etc. Most these are done by different professionals. Few law firms offers tax advisory services, but not tax planning, but very few. In essence, there is a division of these services by professional specialty. Okay.
Yes, thank you. Thank you so much. Diana, we've heard about the recent trends, but in your opinion, what are the best practices when it comes to structuring cross-border estates, particularly having overseas assets? And in giving your answer, maybe you can make explicit reference to wills, what we've considered joint wills, and trusts. Thank you.
Melissa, I agree with what Mona had said earlier regarding structuring of cross-border estates, that it's very important to understand that different jurisdictions have different laws. So there is need to work with experts in those jurisdictions, yeah? So that said, as I had earlier pointed out, there may be scenarios where, particularly when it comes to will, I agree entirely that if you have chosen to go the will way, then use the will crafted in accordance with the jurisdiction of that country. Because, for instance, as we pointed out in Kenya, as Mona had pointed out in Kenya, first of all, our law of succession has a prohibition with regards to dealing of immovable property based on the laws of any other country. So you'd have to, even though you had a will that was purporting to tell us how assets are devolving in Kenya, you'd have to come and reseal it in Kenya, and then it's adopted as an order of the Kenyan court, and at that point, that's when it becomes enforceable in Kenya. So that process, as Mona had pointed out, you can end up making it very lengthy for your client, just because you did not follow the laws of that jurisdiction. So that's with regards to wills and overseas assets. With regards to the concept of joint wills, I caution my clients against the idea of joint wills, because I think the premise of a joint will is that once I pass on, first of all, there's what we call testamentary freedom, meaning if, say, husband A and wife A have contracted a joint will, then husband passes on and wife has been left. There is no requirement in law that she must adhere to this law, to this will she had crafted with her husband. She could make a decision to say, now that the assets have devolved to her entirely, maybe the will had provided for the assets to devolve to whoever is surviving. Now that the assets have devolved to her entirely, she still has testamentary freedom under the Law of Succession Act to change her mind and now draft the will to whatever new specifications or new circumstances she has. So the idea of joint wills, I don't usually advocate for it. If there is joint ownership of assets, then the law is already, like under Kenyan law, joint tenancy means by operation of law, the principle of a survivorship applies. Therefore, whoever dies first in time, the other one acquires full rights over this property. If it was a tenancy in common, these are the severable rights. Therefore, I'm able to bequeath my half, and my husband or the other party is able to bequeath his half. So that's with regards to the question of joint wills. Then lastly, with regards to family trust and trust in general, I also urge into looking at what the specific jurisdictions provide, but you have to understand that the way trusts are created globally, not just in Kenya, the law of trust globally is evolved so that it can actually take care of some of these sometimes multi-jurisdictional issues. So that you can, for instance, in the past, you've heard about a lot of offshore trusts having people who are holding their entities in Kenya owned by trusts, say, registered in Mauritius or in other tax havens. So in the past, considerations have been number one, based on those better tax regimes, and also number two, based on reporting requirements and everything. But one of the issues we've encountered lately with offshore trust is the high cost of maintenance, so that sometimes the cost is outweighing the benefit it's giving, particularly now with the change in reporting requirements world over, you know, with I think with the London Treaty, it was called the London Treaty, the one that operationalized the concept of BOs. With it having been signed by so many nations, now that has been overridden, so that you will find that the information sharing is that much more, so that it might not make sense. So in a nutshell, what I'm saying then is, there are instances in which we can have a trust that owns shares, a Kenyan trust that owns shares, say in Uganda or in Tanzania, but it's not a one-fits-all situation. I will look at the client's objectives, I will look at the laws of that land, I will look at the tax implications. That's very critical. If we don't have double tax agreements with such jurisdictions, it can be very tax onerous on the client. And then I will also look at the apprehensions. What are we trying to guard against? Then finally, as had been pointed out, global mobility is a big issue now. So domicile. I'm seeing a lot of clients these days who are coming to retire in Kenya. They worked all over the world. They worked for, say, organizations like IMF or other organizations that are ordinarily tax exempt, and therefore now they have this worldwide income coming into Kenya. So we have to look at how this income is being taxed, and then make a decision as to whether the Kenyan trust is a suitable tool or not. Yeah, so it's never a one-fits-all situation. It's a case-by-case basis, depending on the client's objectives, the client's apprehensions, and now prevailing laws, and a key consideration on tax, because you don't want to create a tax onerous issue for your client, like a tax onerous structure for your client. And then with regards to what you'd earlier asked about, I think about the trends, I just wanted to jump on there and also say that I think another trend that's I personally like is we see as now family offices are coming up. Like now the management, we're all agreeing as experts, both the legal and the financial experts, that ultimately wealth management is not a purely legal issue, and it's not a purely tax expert issue, and it's not a just investment issue. All of us, the tax guys, the legal experts, as well as the finance experts, who are the investment managers or whoever else, have a role to play. And what we're seeing is this concept of family offices now developing quite fast. So a family office is basically just a team of professionals with all the competencies I've mentioned, legal in terms of wealth structuring, tax in terms of the tax planning, investment in terms of, because after I register the trust and I've incorporated the trust, I hand it over to people like at Moran, at Alex, who then advise the clients on how they're going to grow their trust fund so that it can meet the objectives they've set up. So if they have set up trust that is going to cater to, say, education up to the 4th generation. And right now their trust fund is at 100 million in X assets. Now someone at Moran like Alex will sit down with the family and craft an investment strategy that will show the family how they then grow this investment, this trust fund. There will be restriction within the trustee as to how much can be, as to how the trust fund can be used up over time in relation to the objectives we set up. So what we are seeing, and I like, is now the idea of this like family offices coming up. We're seeing a lot of people setting up in Kenya, and that opens new opportunities for lawyers so that you don't just have to sit in a traditional law firm setup and just, you know, do conveyancing and commercial work and restructure. You can do some sophisticated practices like this that involve a lot of interaction with finance experts, with families one-on-one. Yeah, so I like that that's happening. I think that's giving us a lot more as to how we're not just traditional lawyers who have to be in suits all day in courts. We can be the kind of lawyers who are actually involved in, you know, dynamic stuff that's going on and is changing. I also like that what Dr. Honoraria said in terms of the changing, the sophistication in assets. You know, asset classes have really changed. Just today, I was having to discuss with someone what would happen if, for instance, X party dies and they have cryptocurrency wherever and they haven't disclosed it. You know, like in Kenya, with once the UFAA came up, the Unclaimed Financial Assets Authority came up. At least now we know with traditional assets where the money would be routed, or where the benefits attaching to these assets would be routed. But now, what about assets like cryptocurrencies? You know, or even, as he was pointing out, other types of digital or virtual assets. And I can't wait to see where that goes. I'm really excited to just, you know, see how the law develops with regards to that, so that even as estate planning lawyers, we're not just also now restricted to the normal probate and admin. there's so much more that we're doing, and it's really exciting.
Thank you. And that's very interesting on the family offices. So to all of us lawyers, I'd encourage that we read up a bit more on that. And Diana, just playing devil's advocate here. For example, your client comes in with his cross-border estate, and despite your advice on having different wills, he insists, or he or she insists, on having a worldwide will that will govern all these assets. How would that work practically? Like, so you draft the will regarding the Kenyan assets, and then now you liaise with a lawyer from another jurisdiction. Please just quickly run us through how that would work.
Yes, I also would like to hear what Mona and someone else say about this, but let me give it a try. So first of all, I like clients who recognize my role as counsel. I'm giving counsel. That's why you came into my office. So if I tell you this is the way we do it my way. We don't do it your way because I went to law school. I say that with kindness. But let's say if a gun was put to my head and I had to draft a worldwide will, I would just draft it in accordance. I'd first of all, I'd pick and this is if there's a gun to my head, I'd pick the jurisdiction that has the bulk of the assets. So that's the one I'd use as the first jurisdiction where this will must be then proved. And then number two, of course, whether or not I put it in the will, the laws of those other jurisdictions obviously dictate, as I told you, like in Kenya, you'd have to come and reseal that court order you got them from whichever jurisdiction for it to be applicable in Kenya. So I would, of course, then subject it to the other jurisdictions and to the other laws. And also, the only value I see that such a will would have is making sure that I list very carefully how this asset, what these assets are, how the proper, say, title numbers, where their title documents are, so that at the very least, if it was to fail, say in jurisdiction A, where the bulk of the assets are, because like consider in Kenya that wills are invalidated. So if we drafted for someone who had holdings in Kenya, Tanzania, and Uganda, and then the will is drawn according to Kenyan, is drawn quote unquote as a worldwide will according to Kenyan law, then it fails in Kenya. It's invalidated in Kenya for failing to meet a certain threshold, as set out in our Law of Succession Act. How can you then purport to go and enforce it in, say, Tanzania or Uganda or wherever? So those are some of the reasons why I will never advocate for a worldwide will, and I would prefer, if we're going the will route, we stick to the specific jurisdiction for which that will be applying. But again, if a gun is to my head, that's what I do, but I'm counsel, so I'd rather not.
Yeah. Thank you, Diana. Mona, do you have anything to add on to that?
Yes, I agree with Diana. And what I would add on is to say that probate processes in each jurisdiction have varying lengths of time. And I would just explain to the client that if you have just one will, and let's say the will is being first probated in Kenya, and there is a dispute, you will not be able to send that will to any other country, because each country would require the original will to be produced to the court. So basically, if there's a dispute in one jurisdiction, you cannot proceed to send the will to other jurisdictions. And basically, if your family does not have the required liquidity to be able to go on for a few years without having access to the assets in your estate, basically the family is just going to be stuck. So it is, when you're taking instructions from a client, when the client is insisting on certain things, we need to explain from a practical point of view how probate works, and the requirement for a will to be produced in every jurisdiction, and why we're insisting on doing things in a particular fashion. But then ultimately, as even Diana says, we have to take instructions and advise to the best of our ability.
All right, thank you very much. I will now head over to the finance experts. Alex Mungai, perhaps I can start with you. Given your expertise in finance, how do you guide clients through the financial aspects of cross-border estate planning, especially concerning taxation, asset management, and international investments?
Right. So when we are dealing with, cross-border planning, we start with looking at what are the goals that you want to meet in each of those jurisdictions and in the long term, regarding your assets, your liabilities, beneficiaries. How do you want to settle those in the future? So you want to have those discussions. Who do you want to manage what? Those goals are very important for us to get clarity on. Income goals in those various areas, obviously driven by what are the liabilities to be met in each of those jurisdictions now and in the future. So how much do you think it will take to run the obligations in that area, so that we can figure just how do we structure the assets, as well as currency investments to meet their right liabilities. So we're always looking at how do you hold your assets based on those liabilities that you expect to incur there. We also obviously look at the tax treatment of the various assets in those markets, as well as also the investment laws in those various markets, the volatility or the veracity of the laws in those areas. We are always looking at that so that we can tell whether they hold between when we made the decision to invest and when we come to look at the investments a few years down the road. Is this a jurisdiction which has stability in the laws, or should the structure be held in another space and just the income is coming from another jurisdiction? So we want to be very clear on those things. So we talk a lot with the legal teams in those areas, and we also look at the financial laws and how delicately they are followed in those areas. We prefer obviously working in areas where the jurisdiction is the laws are followed, because that is a major part of ensuring we can mitigate risks. So the major issues we are looking at when we are planning is the goals that the client has, either for settlement in the future for beneficiaries, or for the liabilities they have and what obligations they're trying to settle in the various jurisdictions. So those form the start, and they can tell us how aggressively we can be positioned in any one market, or just if the growth of that market is very aggressive, then we can tell how much exposure we could have in that market. We also look at obviously the stability of those economies. So those are the issues we are normally looking at when we are planning, so that we can tell whether we'll realize the dreams of and aspirations of the clients.
Thank you. Very well put, Alex Fungai. Thank you so much. Kamoga, now based on what Alex has said, how do you now mitigate financial risks and optimize investment strategies to ensure the preservation and growth of assets for your clients across international borders?
Thank you, Melissa. Thank you. The past speaker, he highlighted most of the things you consider, while making decisions on taxes, asset management, and also international investments. Now, how do you optimize investment strategies to ensure preservation and growth of assets across border? Now, here in Uganda, there are laws. We have the Financial Intelligence Authority that sees, people with money, where are they getting it from, sources of their income, are they doing money laundering and that kind of thing. So who does that? Who oversees that? Fund managers don't probably receive money directly. They go through probably a custodian like the bank. The bank does the background check that this one deposit 1 billion shillings. Is it from legitimate sources? Of course, now it's from someone's trust or something that was in the will, or someone disposed of their asset and now they're going in cash. So the bank mitigates that on our behalf as fund managers. They do diligence on the money that's coming in. Also, there are laws that help us, to use anti-money laundering laws to find sources of income, sources of someone's money, the collection points. Yeah, like now we have MTN and Airtel, all those integrators, and then the banks help us to collect money. And those guys have done probably they've saved that money, and they get to know where the money is coming from. So as fund managers, it becomes easy for us to invest on behalf. Now, also you must have corporate trustees, licensed corporate trustees, licensed custodian, the guys who oversee the activities of the investment. Yeah, so that everything is going the right way. Also, it's very nice to diversify and invest money probably in treasury bills and bonds, unit trust funds, then annuities. The things I talked about earlier on, it's good to diversify in those, those assets to maximize on your opportunities of earning money. You also need to, we are compliant as fund managers, as well as the bank, or people doing stocks are compliant, giving reports to the government on how, the money is being collected, where you're investing the money, and all that kind of stuff. Then, of course, they look out for tax incentives, be able to maximize on returns. Yeah, and also know when to buy and when to sell your assets. Yeah, and in case you're doing shares now, or in case you have a fixed, in case you have a treasury bill, know when to liquidate it and know when to to buy more. So the things are very important for us to for us to maximize on our returns on our investments. Thank you, Melissa.
Great, thank you so much, Alex and Kamoga. That was very insightful. So I think given the time, we can now try and answer some of the questions from the audience. I have them here in front of me. The first question that I would pose, it's addressed to both Diana and Mona. So I'll just read it out first. Diana, sorry, let me mute. Diana, for a family trust that is created when the settler is alive, what mechanisms can be in the trust deed to enable him to have control of the trust while still alive? Can he be a beneficiary under the trust? And can he have veto power? And also, can he dissolve the trust? The second part is to Mona. What are recommended restrictions on the powers of trustees that should be in the trust deed? Can a family trust be dissolved? If you can answer that really quickly.
Thanks, Melissa. Both parts are related, so I'll touch on both, and I think Mona will also touch on both. With regards to whether the settler, what mechanisms can be put in the trust to enable him to have control of the trust when he's alive. So first of all, we're talking about a living trust. There's two ways to create a trust, either as a testamentary trust, that is by your will, which I don't advocate for because you're subjecting it to the will, to the probate process. Then number two, as a living trust, which is created when the settlor is alive. So now once the question here is what mechanisms can be put in the trust to enable him to have control. So a trust can either be what is called a discretionary trust or a fixed trust. As a discretionary trust, it means we're just simply leaving the discretion to trustees to make certain decisions. Actually, a lot of them. So in terms of control, we are vesting a lot of the control on trustees, and therefore they'll be exercising discretion. A fixed trust is one where now a lot of the entitlements in the trust with regards to say like how much a beneficiary gets are fixed, so that now whether or not the trustees have little leg room to play. So they know that if there's income and there are 5 children, we fix that everyone is getting 20%, or we fix that every X person gets 10% and the other person gets 90%, like that. So that's the differentiation. So if we're trying to ensure that control vests in the settlor, which is something the law allows, then you want to either have a discretionary trust, that's one way. Number two, yes, you are allowed to create, in the same way when we draft shareholder agreements, you're allowed to create, say, a reserved matters clause, or have a casting vote on the chair. You're allowed to use such clauses and such corporate governance tools to vest control in the founder, in the settlor. Also, the law allows for a settlor to be settlor, trustee, and beneficiary. So he can be all three things. The caution here, and that's why now you need a lawyer who has a good understanding in these matters, is that you must guard not to create what is called in law a sham trust. Yeah. So there is a lot of case law, and you can find it. I won't regurgitate it here. You can find it online. I think we've written a bit about it. There's an article we've written on sham trust. You can look it up on the internet. You have to make sure that you don't create a trust that is a sham for all intents and purposes. Like you are just trying to either evade creditors or to go around some laws. Yeah, so that's the biggest issue. That's the biggest caution. I think I've answered. Yes, I think the second part is for Mona. Recommended restrictions on the powers of trustees.
So it's again important to understand what the settlor is trying to achieve. If he doesn't want to give full discretion on trustees to do all kinds of powers, he can restrict the powers under the trust deed such that certain powers need to be, by way of consultation with, for example, what's called a protector. A protector is an office that is created where you nominate one or two persons to basically oversee or supervise what the trustees are doing. So if you do not want to give full control to your trustees, then the office of protector is a mechanism which you can utilize such that when the settlor has passed on, then at least he knows that this office of protector is there, where the protector will look at what the trustees are doing, and for certain decisions, the trustees will need to consult him. Thank you.
Great, thank you. One of the questions within that was, can a family trust be dissolved? Mona?
Yes, I mean, it can be dissolved. You see, like you need to have special dissolution clauses in the trust deed to say what then happens to those assets. Are they going to be dissolved when the beneficiaries are of majority age? Who is going to benefit from it? So all those kind of provisions need to be drafted very carefully. It is not that the settlor can just create a trust and then dissolve it at any time because he used it as a sham mechanism. So, I mean, it needs to be very clear as to how the dissolution is to happen. But yes, it is possible.
Melissa, if I could also just jump onto that. When drafting a dissolution clause within a trust, you can either have it be event-based. So you can say, as Mona has pointed out, when the beneficiary, maybe the youngest beneficiary turns 18, or when whatever event you want to be triggered, or acquires a first degree and has turned 25, or gets married, whatever event you want. Or it can be discretionary as an exercise of all the trustees, not just the founder alone. So that, for instance, if whatever maybe changes in law, for whatever reason, the trustees who have full discretion about the trustee make the decision to dissolve, that they can now do that as the full board, not as a founder in his own by himself. And then also it can be for a fixed term. We have a lot of trusts that are created for a fixed term. So for instance, for the next 13 years, then after 13 years, it shall automatically dissolve. As Mona has pointed out, the clause would then go on to discuss a distribution clause. A dissolution clause goes hand in hand with the distribution clause, which says upon termination, how assets shall be divided. So whether it's a discretionary distribution or it's a fixed distribution. And then it is important to distinguish dissolution of a trust with what is called revocation. So you are at liberty as a settlor to create a revocable trust. That is one where you can exercise the power to revoke the creation of that trust, the same way you exercise the power to create it, right? So a revocable trust would be stated within the deed as revocable. The biggest issue with a revocable trust is, whereas an irrevocable trust, particularly one that culminates in incorporation, creates a body corporate that is separate from this founder or settlor, and therefore all the assets vest in this juristic person that is the incorporated trust. A revocable trust is still, because you have the power to revoke as a settlor, it still sits in your discretion fully to revoke it. Therefore, if there was a creditor, for say a bank was enforcing a personal guarantee against such a settlor, assets that in the first case where there was an irrevocable trust and the assets had already transmitted and the assets are now held in the name of the trust, then those assets cannot be executed or attached by the bank that is trying to enforce the personal guarantee. But in the case of a revocable trust, yeah, one where the settlor has the power to revoke the trust, the lender or the person trying to execute against this settlor is at liberty to move to court to compel the settlor to revoke because it is within his power. So that's the danger of creating a revocable trust, is that once, I think we didn't go into the point where we tell you the benefits of the trust, but one of the key benefits a trust affords is that protection from third parties. Under Kenyan law, it is protected from insolvency proceedings. If the settlor was coming under bankruptcy, it is protected from insolvency proceedings and under related entities because it's a separate and legal person. And then it's also protected from matrimonial property disputes. Assets in trust are not matrimonial property assets. And then it is also protected under, there's a fourth protection basically. So it offers a very, what we call a very all-rounded asset protection benefits. So now if you create it as a revocable trust, you lose some of those asset protection benefits. Yeah, so that's it.
Thank you so much, Diana. And that actually ties into the next question, which is also addressed to you. One of the benefits of family trust was taxation. So what the question here is, hi Diana, kindly shed light on the taxation of family trust in Kenya in light of the Finance Act 2023. And I know that's a lot to delve into, but maybe you can just give an overview.
Okay. Yes, thanks, Melissa. I see there's another question on taxation of family trust. I don't know if we take them all together so that we don't have to come back to the issue of taxation again. Is that okay? I think there's one more at the bottom. So the second one.
Sorry,
yeah.
Go ahead.
I see also a second one that says, hi Diana, please clarify whether a trust registered in a tax haven can enjoy the tax, that's CGT and stamp duty benefits in Kenya granted to a family trust when transferring property to the trust. I don't know if there's another question on trust on taxes. So anyway, let me deal with those two. So as I had said earlier, Finance Act 2021 created some very good tax benefits for family trust in Kenya. It's we laugh about it here because the Finance Act 2021 came into operation 1st July 2021 before the actual law on the changes of incorporation of family trust changed in December 2021. So we got a better tax regime even before we had clarified exactly how family trusts are now going to be registered. But we all knew, all the practitioners knew that the bills were in Parliament, so we knew it was just a matter of time. So anyway, with that, what are the tax benefits? So number one, under paragraph 58 of the first schedule of the Income Tax Act, the income and principal, the principal and income of a family trust is tax exempt. That means if a family trust owns, has gone to Moran Capital, and Moran Capital has advised that let's buy some bonds, let's invest in real estate, it owns an M house and it owns which other type of estate income, investment income, it has a fixed deposit in Cooperative Bank or wherever, all the income it's receiving and the principal, whatever assets we settled into it, is tax exempt, meaning when we're receiving the bonds from Kenya, when we're receiving the payment of interest for the government security that the trust has purchased, the withholding tax will not be charged on it. Yeah, so there will be no tax on it, so it will be exempted. That's as distinguished, for instance, if I held that bond in my name. If I hold it in my name as Diana Muriithi, I will be taxed a final withholding tax of 15%, but Diana Trust would not be taxed anything. So if my interest was 1 million shillings, I would get 850,000, but Diana Trust would get its full 1 million shillings. So that's one benefit we got in 2021. The second benefit we got in 2021 was if you're transferring assets into a family trust, whether now this is immovable property or even shares, the stamp duty is exempt. This is under section 52 of the Stamp Duty Act, 52 or 53, I think 52 of the Stamp Duty Act. So you just need to forward the deed to the collector and it will be marked exempt. The catch here is that it must be a registered family trust, yeah? And we didn't get into this, but a family trust has 2 levels of registration. One is registration of the deed under RDA, then incorporation, meaning having a simple trust which is simply registered under RDA qualifies for these exemptions, even though it hasn't gone all the way up to incorporation. But as legal experts, we advise on incorporation because of the benefits of separate legal personality. Then number 3 benefit that came in place is under paragraph 57, paragraph 36 of the first schedule of the Income Tax Act. This relates to capital gains relating to a transfer of property into a trust. So if Diana Mureithi is moving property, this building, into Diana Trust, then I would be exempted from paying capital gains tax. But it's also applicable if I was moving this asset, if I was selling this asset and then settling the funds into the trust, that the proceeds thereof into the trust, that would also be exempt. So a fourth benefit that came in 2021, but was deleted in 2023, was the classification of distribution to beneficiaries. So pre-2021, distributions to beneficiaries, I think, were taxed at the corporate tax, I think like the graduated scale, but on 1st July 2021, the Finance Act 2021 had provided for a classification so that education, medical, and housing were fully exempt if you're distributing for those three reasons. And then any other distributions were up to a maximum of 10 million per beneficiary per financial year. So to explain that, if I had 5 of my children listed in my trust, I could have distributed up to 50 million per financial year, and say myself and my husband. So that's up to 70 million for the beneficiaries in a financial year. But that was deleted. That was paragraph 3A, section 11(3)(a) of the Income Tax Act. That was deleted by Finance Act 2023, so that now there is no classification of that, and the absolute exemption on education, medical, and housing has now been deleted. So now the current position with regards to distribution of, with regard to taxation of distributions from a family trust is under Section 11 of the Income Tax Act. And basically, we need to consider the source of income. So where the income is coming from, qualifying dividends or qualifying interest, it will be exempt. The distribution will be exempt under 11(3). And even when we're distributing to the beneficiary, it will be exempt. Where the source of income is, where it is structured as an annuity payment, it is also exempt. In every other case, I think the current threshold is 5%. I know a key, let me just mention that a key confusion I've seen in practice is paragraph JB of the, paragraph 5JB of the 3rd schedule of the Income Tax Act had come in 2021 with the Finance Act 2021, creating a tax rate of 25% for anything above 10 million. However, what you need to realize is that that paragraph references an non-existent provision of law, and you know how now laws are interpreted. It references Section 11(3)(c). There's no such section in the ITA. Number 2, it meant to reference Section 11(3)(a). But so now, when Finance Act 2023 has deleted Section 11(3)(a), again, it remains obsolete. So it's an obsolete section that's still sitting in the Income Tax Act. When we were forwarding comments for Finance Act 2024, we forwarded it as one of the comments. We're hoping to see it deleted now with the Finance Act 2024. But yeah, we're going to see it. So with regards to advising your clients, I know there's a lot of confusion. People say that the distributions are very, they're going to be tax onerous, but just based on what I've explained to you and a clear reading of Section 11 and good drafting of the trust deed, you can avoid onerous tax burdens for your clients even when distributing. I hope that is clear.
Thank you so much for that, Diana. I know it's a bit technical when it comes to the tax aspect, but I think we just need to read up a bit more just so that we're sure of what the current position is. I'd like to now pose a question to Dr. Honoria. The question was, out of your experience, despite the old trust laws and the lengthy procedure of registering trusts, why is there so much bias against trusts? A few clients I have advised never seem to appreciate the concept to the extent that one told me trusts are for Indians. How best can we overcome these kind of perceptions? Thank you.
Yeah, that's very interesting. Well, I think it's more about the fact that if you look at the history of trusts in Uganda and the way they have been used, that's where that perception comes from. I think when people look at the trusts in Uganda, I think there have been few and far between. I think most people now, they walk in the middle of town and they see the Diamond Trust building and they think, okay, that's the typical example of a trust, and it's held, that property is held by Indian family. But I think one of the things I think we have not really popularized trusts as a vehicle for managing wealth. And also, I think because trust law and estate planning law is very recent as a course taught at Makerere, and because it was started, I think most students, and I have a feeling Philip Munabi was one of those, the person who has posed the question. It wasn't really very attractive as an area of practice. That you studied it as a course, you ask yourself, where is it going to be applicable? And that has been, if I was to say, that's been taught since about 2000. So you have about, how do they say, 20 or so years of people who have learned trusts and estate planning law. And I think their experience even in school wasn't really that fun. It was a very difficult course, so not many people took it up. But also, I think, as I said, we've never really popularized the idea that trusts can be a very good estate planning tool. We've not gone out to, if you look at because normally this thing requires you to have it something that is part of, say, the CLE training, part of sensitization of the public. When you look at most times when they're talking about how to manage property, that has never really been. People will tell you, okay, set up a company, do a business, grow wealth, get rich, and that's it. Nobody ever tells you that you can find a way of actually growing that wealth beyond a generation. So I once went to attend a training, and one of the things that the trainer asked us to name any company in Uganda which has lasted 50 years. And he was not talking about, he actually specified Ugandan owned company that has lasted 50 years. And none of us could find an answer. Because most of the companies were collapsing after one generation. There was no cross-generational delivery of this wealth. And I think that's where it shows you that we have not really, and even the people who are well-to-do, I've thought that if I can invest my money in shares and all that, whatever happens, they have not really thought of what's the vehicle to move that wealth into the next generation. Even right now, I'm sure Kamoga, I saw him shaking that if you look at the kind of disputes that are now revolving around some of the rich families who have died recently, BMK, I'm trying to think of who else, and it's very untidy because they never thought of how best way to provide a vehicle for this wealth to move to the next generation. The next generation is fighting over that wealth. And so I think to answer I think what we can do, let's try to sensitize people about trusts. We may need to change the law. I know the Uganda Law Reform Commission in Uganda is working around. They have done a consultancy over the reform of trusts law in Uganda. Maybe if we can begin getting that done, then after the law is in place, we do post-sensitization on trusts. Then we'll begin to see people with a new regime, a more vibrant regime, a more like the one of Kenya. If more people can begin to understand that, hey, we can create family trusts, then we might probably have a driver for getting this off the ground. And that also speaks to, I think there's a question there about the best estate planning tool and why wills are there many wills contested in Uganda. As I pointed out at the outset, COVID showed us the shock that many people are not doing wills. So you might find the reason why there are not many wills contested is that there are not many people making. If you look at the jurisprudence in Uganda, actually, most times because people are dying intestate, most of the disputes are ending up in applications for letters of administration for someone to administer the estate rather than go for probate for someone to execute estate according to the wishes of the owner of the deceased. So that's, I think we need to begin both encourage people to look at what are the various tools and the look at wills, look at trusts, look at foundations, and also, and I think probably one of the things we need to begin telling those who do wills, don't will away the property that creates wealth. What I call the golden egg. You cannot begin redistributing the very thing that makes the wealth. So you find you have property in Kampala, Nairobi, then you begin willing away even if you will sections, you say, okay, you will get this floor, you will get this floor. They will send it off in order to get. I think the idea is that we should begin creating family trusts, which then where we protect the property that generates the wealth. It's easier for you to will off cars, will off residential places, but the one which is generating wealth, we should be protecting it. And I think if we can get the tools right in Uganda, get the new law in place as it's being proposed, and then sensitize the people about doing wills, doing trusts, doing investments that bear in mind so many things. For instance, I'm sure Kamuga knows many people are investing in collective investment schemes and unit trust. But the question at the end of the day, they're doing the insurance investments in insurance services. The question is, where does that money end up? That's the question I think that would be critical. Where will it end up once if someone dies? It will probably end up in the hands of the people who, because they are not trained or they have no idea of estate management or that this wealth needs to be grown, it will just get lost in that generation. Thank you.
Thank you so much. And while I still have you on the mic, may I please have your closing remarks in a minute or so? And in your closing remarks, you could mention what would you like to see happening with cross-border estate planning, or any advice you'd like to give to the people that are tuned in. Dr. Henry? You're muted.
I think we just need to, I know there are probably a whole bunch of, not just lawyers, I know this was a segment from the East African Law Society, so the majority of the people are probably logged in from the legal profession. I think we need to broaden our horizons, and I think I've always told my colleagues that we tend to sometimes think inwardly. A client comes to you and we are thinking, okay, how can I get the quickest legal fees from the client? We're not thinking, what can the client do? Especially in the context of greater integration in East Africa. I should be able to tell the client that, you see, now that you want to set up this business, even if it is say fishing, I should be able to tell you, okay, what are the opportunities to grow that business in Uganda, but what are also the opportunities for you to expand the market for your fish across East Africa. If someone wants to invest in a real property and all that, I should be able to tell them that there are also opportunities to do a number of things. If you want to get into buying shares or any other form of money market, so I should be able to tell you that why restrict yourself to Uganda and the government securities offered in Uganda? Can't you look to other jurisdictions? And then be able to tell them, okay, we can give you advice, we can get you people across the border to advise on specific nitty-gritties, on procedure, on the financial taxes. So I think as lawyers, we need to think broadly for our clients and not restrict ourselves to our jurisdictions. If we're really going to help them grow their wealth and have it properly managed, have it properly in accordance with the law. So I think for me, that will be look out for the opportunities. And as lawyers, they always say the best lawyer is not the one who knows the law, but where to find it. So as lawyers, we need to continue to invest in reading and learning. Sometimes even unlearning. Sometimes we get stuck on ideas that have long passed. So we need to say, okay, let's go and learn about this particular area, and you understand the area, and then better be able to advise your client. But also as lawyers, we need to begin, as has been pointed out, we need to sometimes take our own advice for our own. Let's do wills. It's very sad for lawyers to die when we have no wills and we are not taking advantage of what we know. It's a good tool for estate planning. Yeah, so those are just my final remarks.
Thank you. Thank you so much, Dr. Honoria. Mona, so really quickly, there was just a question regarding family trust. If you would recommend advising clients to establish or register family trust in multiple jurisdictions for similar reasons that you would have them have multiple wills. And in answering that, if you could also give your final remarks in a minute or so. Thank you.
Sorry, was that for me, Melissa?
Yes.
Okay.
Did you,
okay. Basically for, yeah, I mean, what I would say is it's important first to understand what the client's estate comprises of, what the family estate comprises of. And then if it is, then maybe you do a hybrid of a trust, and also whichever assets are not in a trust, put them in a will. I wouldn't say that for each jurisdiction you need to do a trust. Offshore trusts also cover many jurisdictions. So if you have assets, for example, in the UK, you may wish to consider Jersey, Cayman Islands, a lot of other jurisdictions, you know, and put those assets into an offshore trust. For local assets in Kenya, for example, you may wish to set up a Kenyan trust, or even think about if an offshore trust is better, but it would be important to get that legal advice. When you're setting up a trust, the jurisdiction you choose is very important. Just setting up a trust is not a simple affair. You need to know why your client wants to do it, and also there are expenses attached to it. So a trustee will charge annual fees. There will be other expenses involved. So depending on even the value of the estate, it is important to look at whether it is necessary for your client, and if it is, which jurisdiction are you going to choose. And transferring assets into a trust is not it's not free. So you need to look at how cost effective it is, whether there are any stamp duty or other taxes that you need to consider, and how to structure it so you may, you know, save on those kind of taxes. So it is important to have an overview of what the client's objective is, what the assets are, and what makes sense, you know, to do, keeping into account costs as well. My parting remark is that wills and all these estate planning tools that we've discussed is applicable to everyone, whether you have a global estate or whether you just have assets in one jurisdiction. Whether you feel you have a large estate or a small estate, at the minimum, at least have your will in place. Thank you.
thank you very much. Diana, if you could have your final remarks.
So I think I see there are 122 attendees. I figure most of them are lawyers. I like what you said before, that doctors make the worst patients. I hope lawyers are not making the worst. I hope we're taking our own advice. I hope we've structured our estates. I hope we're taking advantage of the tax benefits that we've explained. I hope there's plans, you know, so that we're not going to see one of ours at the estates being fought for in causing a dispute that's sprawling over 10 years or 5 years or even 3 years, or even having to resort to your holdings going to UFAA because there was no structure, there's no way to actually find them. So I think mine is a clarion call to every lawyer who's on here. At a minimum, if you won't even plan your client's estates, plan yours, because death is the only common denominator among the 122 or 132 of us who are in this panel session right now.
Great advice. Thank you so much. I think Dr. Nguluma has dropped off. So I'll ask Kamoga for his final remarks in a minute or so.
Thank you, Melissa, and happy for having invited us to share insights about asset management and private wealth management. And thank the panelists that I personally learned something about wills and trusts, all those things. I'm impressed. Yeah. So yeah, it's important for us to think about the tomorrow and not only think about the now. That's because most times the tomorrow is 10 times more important than the now. So it's important for you to plan well and then save money and invest. Yeah, those are my parting shots. Thank you, Melissa.
Thank you. Last but not least, Mr. Mungai, your parting shot.
Thanks, Melissa. I think my observation is, first of all, thank you for putting the session together. As Moran, we are a family office and very keen on making sure that the generations down the road can ensure the hard work that you're working on translates to them. But I also want to say that Africa only contributes 1% of world wealth to the riches of the world. A lot of it is due to organization. A lot is lost in organization between the first, second generation. And it's a sad affair. That means that everybody down the line is working so hard, yet one person already up the road had enough to set everybody on the right trajectory, and we build on from there. So wealth just tends to be built and lost, built and lost, built and lost. How do we create that sustainability? We are very interested in helping people do that. For example, our firm is keen on making sure we generate the most dollar millionaires in Africa. And that comes from the right structures, the right investment structures, understanding goals, because a lot of people don't even have a goal of what income the estate should generate per month, because they don't know what liabilities they're meeting. So they're just building assets without clarity on what is the goal we are actually trying to achieve with this estate. And we help people clarify that, because if somebody comes and says, you know what, Alex, I want to make sure that we get to, 1 million shillings, 5 million, 10 million every single month perpetually that can be paid. Can you tell me what needs to be done? And that's where we are happy to work with Diana. She works around the trusts, make sure that we have protected that against the number of challenges that can come up, but also having the right assets in the right jurisdictions. And that also helps bring in what we call wealth symmetry. Wealth symmetry is everybody knows the information, because nobody fears that if you disclose some of the information, it may be infringed upon or misused. So having the right structures, we are great that the lawyers are able to do that, and having the right investment structure is something we can help with. But that investment is to meet and expect, to make sure that that is something that can be secured and communicated to the generations, and that's how we'll secure the future. So it's a good conversation we are having here. We are happy to be partners in whichever format to create those solutions. But this is a great forum. I appreciate what I have heard about trusts and how to make these things happen for our clients. And we'll definitely be looking into a lot of this, because people are just coming to the realization that you don't have to have all the negative conversations that are in the market. There are actually people trying to structure the right structures and have the expertise to do it. So thank you for putting it together and inviting us to just share what we are doing in the market.
Very
Thank you.
powerful words, Alex. Thank you. Thank you very much. So that brings us to the end of the session for today. Just want to extend big thank you to all the panelists. We've really learned so much from all of you. Thank you so much to our audience for being engaging and having the questions. If you want to make further reference to this session is recorded and it will be uploaded on the East Africa Law Society YouTube page, I think from tomorrow. So just have a look on that. Thank you to East Africa Law Society for this, and thank you to CM Advocates as well for partnering and organizing this session. So thank you so much. It's been a pleasure to be the moderator today, and let's keep having these conversations and ultimately enrich ourselves and our clients. So thank you. Can feel free to log off as you please.
Thank you, Melissa.
Thank you.
Thank you, Melissa, for a job well done.
Thank you, Melissa. Thank you, everyone.
Thank you all for coming.